Hello students, welcome to Legacy IAS Academy. In today's video, we are going to discuss about the recent judgment that has been given by the Supreme Court of India related to the Section 6A of the Citizenship Act. Now, what was this judgment all about? Why a petition was presented in the Supreme Court, and what has been the overall view of the Supreme Court as well as the government in the entire matter? We'll try to discuss here. So first of all, to give you the reason why this particular Section 6A of the Citizenship Act is news. So recently, actually yesterday itself, in a landmark verdict, the Supreme Court of India has upheld the constitutional validity of this particular act, which was questioned by the petition filed initially in 2012. Now, as per the Section 6A of the Citizenship Act, it basically granted citizenship to such immigrants who have entered the state of Assam before March 24, 1971. A constitutional bench that was comprised of 5 judges of the Supreme Court and headed by the Chief Justice of India, D.Y. Chandrachud himself. The judge with a majority opinion has delivered this particular judgment. However, we have a dissenting opinion by a judge also that we'll discuss in the later part of the video. Now, while reading out the verdict, the Chief Justice of India have stated that while 4 judges, including himself, form part of the majority verdict, Justice J.B. Pardiwala, he has penned a decent note against the verdict. So, if we try to go and look at the background of this entire issue and the issue that was, or the section that was in news is Section 6A. So, Section 6A, first of all, if we talk about, was not present in the initial part of the Constitution, the original part of the Constitution. Rather, it was added in the year 1985. 1985 was the year when Assam, or up to that year, we can say Assam was facing a lot of insurgency related problems, and you have the Assam All Assam Student Union, which was a major, we can say, opposition party. So the Assam Accord was signed between the Rajiv Gandhi, who was that time Prime Minister of India, and the members of All Assam Student Union, which is referred as Assam Accord. Now this signing of accord happened over after a period of 6 years long agitation, a political agitation against the entry of migrants that were continuing from Bangladesh into the state of Assam. Now, the petitioners include NGO Assam Public Work, the Assam Sammilit Mahasangh, and others. They have challenged the validity of Section 6A. They claim that setting a different cutoff date for citizenship in Assam is a discriminatory practice. So, what is this all basically refers to? Let us try to look in more detail. So, first of all, if you look at the Section 6A of the Citizenship Act itself, it clearly states 3-4 major points. First of all, the all persons who are of Indian origin and who have entered the state of Assam before the January 1, 1966 have been ordinarily resident in the Assam ever since shall be deemed to be the citizens of India. It does not matter whether they have migrated from Myanmar, Bangladesh, Nepal, or whichever country. Second, additionally, it provides that anyone who entered and resided in Assam after this date of January 1, 1966, but before the date of March 24, 1971, and who has been detected to be a foreigner, now they would be granted an opportunity to register themselves according to rules that is made by the central government. In other way, they can register themselves even if they have entered between 66 to 1971, and they may be granted certain citizenship. However, there are 2 exceptions that is made in this particular act. The first, it says that after the registration of such people, they would be granted the rights of citizenship, however, not a full-fledged citizenship. Why not full-fledged? Because they would not be granted the right to be included in the electoral vote, and thus right to vote will not be available for them. Now, also, this is not something that would be of permanent nature. Rather, the right to vote would not be granted to them for a period of 10 years after they have registered themselves. Second, it says that after the date of March 24, 1971, any person who enters Assam from outside will be considered as illegal migrants. So this is all what Section 6A basically talks about and deals about. Now, what was the ground on which the petitioners have challenged the constitutionality of the act? Let us try to understand that also. So, first ground of challenge comes from the practice that they believe to be discriminatory in nature, and they believe that introduction of Section 6A basically has violated the right to equality that is provided in the Constitution by Article 14. The reason is because in the state of Assam, there is a different cutoff date for determining the citizenship as compared to other part of India. As we discussed, in case of Assam, it has been 66 or 71, while in case of India, it has been considered to be the July 1948. Second ground, they say that while the provisions also violates the rights of indigenous people from the state of Assam. The reason they give is because due to this increase in the cutoff date or a long time period after independence until 1971, there has been a continuous migration of the Bangladeshis from Bangladesh into Assam, which has led to a perceptible means visible, which has led to a visible change in the overall demographic composition of the state itself. As a result of this, the actual inhabitants of the Assam or original inhabitants of the Assam, they have been reduced to minority in their own state. And as a result of this, since they have been reduced to minority or there has been significant demographic alteration changes, they believe that it has affected the right of the indigenous community of Assam to protect their culture, which again is a constitutional right given to the citizens of India under Article 29. So basically, in essence, we can say the petitioners challenge the validity of Section 6A on the ground of violation of Article 14 and on the ground of violation of Article 29 of the Constitution. Now, based on these observation, what has the court said about the validity of the petition? Let us try to understand that as well. Now, first of all, the court has stated that petitioners have not provided any proof to show that the influx of migrants have altered or affected the cultural rights of the citizens that are already residing in the state of Assam. Second, it also has noted that just because there are some ethnic groups present in this state, it does not merely translate or it is not sufficient to infringe the rights guaranteed by Article 29, that is the cultural rights. And third, the cutoff dates of January 1, 1966 and the March 24, 1971 were constitutional. That is what the court has observed. The reason it gives is because it provides legible conditions for the grant of citizenship and a reasonable process as well. And that is why the validity of petition itself has been questioned. However, government also has come in the defense of the Section 6A, and government basically is defending the Section 6A or has defended it by looking at the Article 11 of the Constitution. Now, in essence, Article 11 of the Constitution grants Parliament the power to make any provision that may be related to the acquisition or termination of the citizenship or any other matters. So far, it is related to the citizenship, and thus Parliament has made this law as per the power. It has not usurped the power, it has not used some extraordinary power or illegal power. Second, the NGO Citizens for Justice and Peace, which was also fighting for reinstatement or basically you can say a continuation of Article 6A, it has said that if Section 6A is struck down, it will also have a negative ramification because all the residents who are presently residing in the state of Assam, who might have came after 66 or 7 or between 66 and 71, they would be rendered stateless because the provisions giving them right or granting them citizenship right itself has been terminated. And thus, after enjoying a citizenship right for almost 50 years, this is something that can be considered as an injustice for them. And third, a change in demographic pattern. You talk about many, the government itself has stated that in response to geopolitical events, that has been the reason behind the change in demographic pattern. Even before Section 6A was introduced, demographic pattern has changed. So we cannot relate Section 6A to the change in demography on the basis of which the petitioners have challenged the constitutional provisions, and that is why there is no need for relating both of them. And even before introduction of this particular act, Assam has remained or been a multilingual and diverse state. So that is the 3 points how the government and the NGOs have defended the Section 6A. Now let us look in details about the court's decision. In this context, the majority decision has agreed with the government's view that the Parliament has the power to grant citizenship under different conditions, but it has to ensure that this differentiation is reasonable, which court believes is reasonable in this particular case. Second, as the migrant situation in Assam, the court believes was unique in nature in comparison to the rest of India at the time, it was justified to create such a law that specifically addressed the situations prevalent in the Assam. Thus, it is not violative to the right of equality that has been guaranteed under Article 14 of the Constitution. And last, the impact of the immigration in Assam was higher in comparison to the other states. So, singling out the state is based on the rational consideration. So this has been the view of the majority judgment of the Supreme Court. However, there has been a dissenting opinion as well, as we have discussed, that is given by Justice J.B. Pardiwala. Now, Justice J.B. Pardiwala, first of all, has termed this act as a full of temporal unreasonableness. The reason is because he believes that it does not prescribe a time limit either to the state government or to the central government for detecting foreigners who might have entered after 24th March 1971 and determining whether they were citizens or not if they have entered between 66 and 71. Second, thus, because the time limit has not been prescribed by the Act, it basically relieves the government of any kind of burden or any kind of duty, responsibility of identifying immigrants and deleting them from the electoral rolls. Thus, he said this is a temporal unreasonable section. Second, he has also talked that such kind of section is a case of illogical uniqueness. Why illogical uniqueness? Because the immigrant must wait for the government to identify them. There is no provision or mandate that requires any person who have entered into the state of Assam to go and register themselves and also tell the authorities and officials what is the time or what is the date in which they have entered the India. This largely has been given to the government and responsibility has been assigned to the government. So the immigrant must wait for the government to identify them as a suspicious immigrant before being referred to a foreigner tribunal for a decision based on the Citizenship Act. So that is why he has pointed a dissent note noting the temporal unreasonableness and the illogical uniqueness of this particular case. That is all about this particular video. I hope you understood overall what does the section 6A of the Citizenship Act talks about, why it was in news, why it was up in debate for discussion, and what kind of judgment and the reason behind the judgment of Supreme Court.